My name is Ernie Brown. I'm a partner with Smith, Currie & Hancock, a national construction and government contracts law firm. I'm going to be speaking with you for about the next 45 minutes with regard to public-private partnerships, or so-called P3 projects, the inside story. We've been fortunate in our San Francisco and Los Angeles offices to be deeply involved in 3 such projects. The first is a classic P3, the Presidio Parkway project. The next is a P3 project in the sense that it has design, build, and operations and maintenance, which is the Oakland Airport connector. And finally, we'll briefly talk about the Mid-City Exposition project, which is design, build, plus project that connects downtown Los Angeles with Culver City, and the second phase will go out to Santa Monica. First, a little bit about Smith Currie. Smith Currie has 54 attorneys in 6 national offices: Atlanta, Georgia; Charlotte, North Carolina; Fort Lauderdale, Florida; Washington, D.C., San Francisco, and Los Angeles, California. We have a national reputation in construction law, government contracts, concessionaire contracts, environmental law, and business litigation. We are in the forefront of this P3 area in Georgia, Florida, California, and Washington, D.C. with regard to public-private partnership projects. And we've been involved in 2 major design-build projects in the largest P3 in California history. A little bit about our friends at BMO Harris Bank. Harris Bank is the 8th largest bank in the United States. As is shown in this summary of some of their projects, they're active in financial advisory and as an investment partner in many of the largest P3 projects in the United States and Canada, which is where their parent is based. The outline of our talk today consists of 8 different pieces. First, we're going to talk about a brief history of P3s, then contract structure of P3s, then some select California statutes, which gives you an idea of the way that states structure their P3 legislation. Next, contracts and risks, P3 case studies, and then we're going to talk specifically about Presidio Parkway project, the professional engineers in government case, which tried to stop that project, and finally a bit about the Oakland Connector Airport, which is a design, build, operate, transfer project. Many people think that P3s are a brand new type of financing, a sort of cutting edge approach to construction financing in the United States. And to some degree that's true. There has been an explosion in recent days, in recent years, and it is one of these things where you can't open up Engineering News Record or local newspapers without seeing some new P3 project announced by either a public agency or a private development group. And there will be literally billions of dollars of these projects performed each year throughout the United States, for as far as we can see. But they're actually one of the oldest methods for delivering projects to the community. One of the very first U.S. Supreme Court cases involving public works at all was a dispute between the city of Boston and 2 private infrastructure companies, if you will, concessionaires. The year of the case, 1837. That case was entitled Proprietors of Charles River Bridge versus the proprietors of Warren Bridge, as you can see, 2 competing bridge owners. The plaintiff had been granted the right to build a bridge across the Charles River by the state of Massachusetts. It eliminated the need to operate the once relied upon ferry, and the plaintiff agreed to pay an annual sum to Harvard College for a period of 40 years, since they had gotten revenues from the prior ferry service. The plaintiffs brought suit against the defendants after they built a second bridge across the same Charles River. Plaintiffs stated that the city's act of incorporating the defendant's new bridge impaired the obligation of their contract with the plaintiffs. The court addressed whether the rights of a primary contract holder could be divested by a subsequent state law. The U.S. Supreme Court held that state law could be retroactive in character and not violate the U.S. Constitution, unless the original obligation was rooted in contract, which they found it was not. As a result, the plaintiff's right to use the waters were not exclusive and not impeded by the defendant's competing bridge. Two very important lessons from that case. One is, if you're going to do a P3 project, try to get exclusivity. The second one is, this case has been cited widely for the proposition that new technology will be allowed to replace older technology, and that the older agreements that may be in place will not impede progress in that regard. Why are we seeing more and more P3s in the United States? Well, there's a fiscal crisis in the public sector. A recent Time magazine covered a story about the Detroit bankruptcy said, "Will your city be next?" And many public agencies across the country, states, local governments as well, are suffering severe budget pressures. Second, there's an increased capital mobility desire from the private sector. Private sector is also believed to be suited to the increased complexity of historically governmental tasks. And finally, P3s are based in market efficiency driven by market incentives. And I'll give you just one example. In the typical design, bid, build case, a designer is paid to design a building, and it may get LEED awards or other environmental or energy saving awards for the design, but very rarely that the architect's going to get a bonus for designing something that's particularly efficient. The contractor will then build what the architect provided. There's really no financial incentive to reduce the long-term operating costs, energy costs of the building. And then at the end of the day, the public agency receives the project, operates it for 50 or 100 years. At the end of that process, probably is going to find that their costs continue to escalate through the entire period. The P3 project substitutes all of that for a yearly availability payment. And it's very important that the concessionaire maximize the ability to save energy and reduce operating maintenance expenses to save themselves money over that long period of time. There are a variety of states that have accepted P3s as part of their contracting practices. Here's a slide prepared by the Associated General Contractors of America that talks about horizontal projects. And horizontal projects are typically those involving transportation, involving pipeline systems, bridges, highways, things of this sort, airports. As you can see, the green states have permitted some form of P3. The red states have prohibited it, and the 10 states, or someplace in between, are not definitive yet. Similarly, this is a chart, again by the AGC, that shows the enabling legislation for vertical projects. These are office buildings. These are courthouses. Sometimes they're sports arenas, other public and civic enterprises that are generally for human occupation use. As you can see, once again, so that upper Midwest area has a lot of resistance to this idea. The coasts are more in favor of it, and the Northeast still has some resistance to it as well. Now we're going to talk about the contract structure of the P3. They're characterized by a sharing of investment risk. And despite the U.S. economic upheavals, the private investment market is still dwarfing the public finance market. Now, surely there is a lot of private money that flows into government bonds, but it has a very low return. And those investors of fixed income securities have very little control over what the cities and counties actually do with the money. P3 projects must promise a significant return on investment to those people who are investing it to make them attractive to private investment. This is because there are risks. There also appear to be specific projects that are particularly suited for P3s and other projects to which P3s are really not appropriate. This is a slide that shows the overall structure of the P3, and it's very, very different from that of typical projects. You do start out with an owner, which is a public entity that has agreed to be part of the public-private partnership. Below that, you have the concessionaire, who's chosen through a process of selection we'll talk about in a moment. We then have, on the right-hand side, some essential funding, maybe state, federal, or private investment, or loan guarantees in some cases. And then on the top left, the funding, which is basically the revenue of the project, such as fare box, tolls, taxes on improvement districts, and joint development, maybe even sweat equity, where participants put in their own time and effort to help make the project happen. Finally, there is often an issuing agency. To the extent that there's an issuing entity required to provide a facility for public bonds and other financing for the project. Then, the concessionaire has a team. That team consists of a variety of individuals and a variety of companies, but they are more or less broken down into three main areas. The first one is the development side. This includes environment, right-of-way, the preliminary engineering, and the financing plan. The next group is the design-build group. And that design-build contract may be a partnership between a design firm and a contracting firm, or it may be several contracting firms that then hire a design firm as a subcontractor. That team is responsible for final design, right-of-way acquisition in some cases, construction, startup, and turnover of the project. And finally, once the project's finished, the project will be maintained and operated by an O&M contractor. Again, someone that's hired by the concessionaire. They will maintain the infrastructure, the right-of-way, perhaps the maintenance of equipment, car maintenance. If there are a lot of mechanical facilities that need to be maintained, there may be a tool facility, and they may also manage the transit operations themselves. As you can see, lots of contracts, lots of complexity. I'd like to now contrast three types of contracting and show how different P3 is from what we normally would see in the public sector. The first example on the left-hand side is the construction contract. And it's basically a construction performed for a fixed lump sum price of plans and specifications that are completed and stamped. The contract is chosen through lump sum bidding. The low responsive bidder will get the job. Design-build contract, on the other hand, includes both the design and build component. And typically, the contractor is obligated to follow a set of schematic drawings and to complete them. In some cases, the schematic drawings are very, very close to completion when they're issued. The design-build contractor is usually selected on a best value basis, and that will include their qualifications, experience, and also their price. P3 contract starts out with the design-build construction, but is also often restricted to a performance standard. So there may not be really the same level of initial plans and specifications or criteria. From that, then the design builder develops a project. And it can be narrowly constrained or it can be broadly constrained in terms of what the owners want. It has typically a selection process that is called life cycle costs. It certainly has qualifications as part of it, but it looks at the entire cost of the facility through the entire project's history, at least for 30 years, in many cases 30 years. Then in addition to those responsibilities, the P3 concessionaire has taken on three new large segments of risk. First is permitting, utilities, and environmental compliance. And again, devil's in the details as far as what those responsibilities are in the contract at hand. They are not all the same by any stretch. Next is operation and maintenance. As I said, a period that might be 20 or 30 years in which they have to do a specified level of performance so that the sensitive facilities continues to be available for the public. And finally, there's a project finance component, which is, of course, the reason to do the P3 in the first place, which allows the private investment. As you can see, these top three contribute a significant amount of enhanced risk to the concessionaire. The typical legal structure for P3 indicates that the development and operation team typically has no interest in the land. There's no fee or lease interest. This has particular ramifications for mechanics liens, stop notices, and other forms of traditional construction payment remedies. The concessionaire structure is used, and a lot of people call this the developer. Many of the contracts say that the developer will be the concessionaire, but that's a little bit misleading. Let me give you this example. If you're really a true developer and you own some outside farmland and you'd like to develop a shopping center, you look at the demographics of the community, the interests of the community, and you put together a plan for anchor stores and a mix of retail and restaurants and entertainment facilities and parking and so forth that will be conducive to a long-term profitable and accepted and enjoyed facility and a good return on investment. Well, being a concessionaire is a little bit more like a person opening a restaurant inside of an airport. It's a much more regulated environment. If you're opening a restaurant in an airport, you know you're probably going to have plastic forks and knives. Your employees are probably going to have to go through screening. You're going to have particular security requirements for bringing in food and exiting trash. And generally your hours and your methods of operation are going to have to be compatible with the 24/7 operation of an airport in the modern age. And that's a lot more like what a concessionaire does in a public-private partnership. A lot more oversight, a lot more involvement by the government agencies each step of the way. The project has to be financeable, and it's quite typical that all or part of the revenues from the facility will go back into paying down the debt. And so, for example, toll road revenues would go back into the project. The payments are usually conditioned on performance. For example, it's very typical for the project to have to be complete and in operation before the availability payments begin. So that means that the concessionaire must arrange for financing for construction and then the permanent financing for the project for the duration of P3. And default by the government agency, if they just can't pay or some other contingency occurs, can result in the loss of their ability to use the facility, which of course then leads to other problems. And unfortunately, that's rare. What are the first steps to doing a P3? Well, the typical way is that a public agency will determine that private financing is desired for a particular project. Once that's done, they will typically issue some outline requirements for the project. A request for qualifications is issued, and then they develop a short list of 3 to 5 proposers who will receive a request for proposals. And they don't usually like to have it be a too large a group, because that means that the individual proposers feel like they have not particularly a great chance, and they may not be that interested in spending the time and money that it takes to develop a proposal. The request for proposal, when it's issued, would include performance specifications, criteria, and proposed project agreements. The proposers would then develop these over 6 to 9 months, including a full schematic design in many cases, and an economic or business model for the project. And a successful proposer would be selected. Those that don't get the job, but did turn in all of their paperwork and their proposal, will often get a small stipend, even if they're the losing proposer. That might be something like $500,000, $750,000, which seems like a lot of money, but it can cost $3 to $5 million for a proposer to put together one of these projects, and a proposal that makes sense and can be innovative and potentially successful. And at the end of that, the public agency has the benefit of all those other suggestions and ideas if they write their proposal properly. We're going to talk about a few select California statutes. These are going to give you an idea of not only what goes on in California, but sort of the issues and structure that's used in many other states. We have 2 major sources of P3 authority in California. The first is Streets and Highways Code 143. It grants state and regional transportation agencies P3 powers. It grants power to the California Department of Transportation, so-called Caltrans here in California, and to regional transportation agencies such as transportation planning agencies, county transportation commissions, joint transportation agencies, and joint exercise of powers authorities. They're often called joint powers authorities. It applies to a broad scope of projects for highway, public street, and related facilities. Planning, design, development, finance, construction, reconstruction, rehabilitation, and other improvements. Also allows the P3 to include acquisition, lease, operation, and maintenance responsibilities. In addition, California has continued to enact further legislation to promote P3 partnerships. It has amended Streets and Highways Code 149.1 through 149.6 that authorizes, in this case, the San Diego Association of Governments to undertake specific toll road and public-private partnership projects. The second source of authority is the California Infrastructure Financing Act, or IFA. That's found in an entirely separate part of the California legislation, which is the Government Code Section 59, 56, and following. It permits private investment in public infrastructure. It's intended to build on the first Streets and Highways Section 143 that I talked about a few minutes ago. It was sponsored by the Consulting Engineers and Land Surveyors of California, which is a private association of engineering, construction, land surveying firms called CELSOC. It was opposed by the Professional Engineers in California Government, PEG, which is the union that represents engineers in California Government. At the end of that discussion in the legislature, the IFA was limited to local government projects and expressly excludes projects by state agencies. California Government Code 5956 authorizes local governments to pursue P3s for a broad range of fee-producing infrastructure projects. It explicitly excludes the use of toll roads on state highways. The IFA states it's the intent of the legislature that local government agencies have the authority and flexibility to utilize private investment capital to do the typical range of services that a P3 does for fee-producing infrastructure projects. The IFA is broad and flexible. It creates an independent authority and does not overlap with other statutes, and it may be used by local government agencies such as cities, counties, school districts, public districts, joint powers authorities, transportation commissions, and other public and private municipal corporations. They exclude from the IFA, obviously, as I've said, any projects involving state agencies being the lead. They may not be used for state projects, toll roads on state highways, state water projects, state park and recreational facilities, state finance projects, in fact, projects that have any state grant monies at all. One example would be state revolving fund loans for water wastewater projects. Those are excluded from this IFA authority. Applies only to fee-producing structures, I've said. Fee-producing means operation of the infrastructure project will be paid for by the persons benefited by or utilizing the project, not general revenues. Examples include utilities, transportation projects, building and structures, including but excluding specifically sports and entertainment facilities. The procurement process under the IFA is, again, it's an independent source of authority, so it's not governed by the Public Contracts Code. The selection of the contractor is through competitive negotiations. Bidding is not required. And the contractors are evaluated on demonstrated competence and qualifications. Unsolicited proposals under the IFA may be accepted. Criteria shall ensure that project is operated at fair and reasonable prices to the user. And that's, of course, to keep the concessionaire from gouging the user or the general population as time goes along. And a government agency may be reimbursed for services provided, for example, planning, environmental review, and preliminary design. Our California Environmental Quality Act does not apply to the selection or the agreement with the contractor, but does apply to the approval of the project. It's under the Concerned Citizens Coalition of Stockton versus the City of Stockton case. Contract terms, again, facilities must be owned by the government agency, leased to the private entity for up to 35 years, revert back at no charge, buyout or termination provisions required. There's a private entity requirement, must provide security for completion of the project, typically bonds or letters of credit, and appropriate insurance. Project must comply with all applicable government design standards for the type of infrastructure. The labor provisions apply, which means prevailing wages for these types of projects in California. Financing sources, private financing, as I've said, federal and loan money, but no state financing allowed. Revenue from user fees can be set, must be set by the government agency with no delegation to the concessionaire. It's dedicated exclusively to pay for the direct and indirect costs for capital and operations. Fair and reasonable prices are required for users. Fees cannot exceed cost of service, and public hearing required to set or change fees, and a private entity must prepare an annual audit, which is available for the public as well. Financing, as I've said, private financing, negotiated reasonable rate of return on investment, federal local money, no state financing. Key limitations. Limited types of infrastructure, no energy transmission projects, for example. 35-year limit on term. Exclusion of state financing. No exemption for property taxes, prevailing wages, and private financing rates generally are going to be higher due to the tax effects. Now we're going to talk about contracts and risks. The risks in P3 contracts are subtle and sophisticated. Although the parties resemble familiar faces, they now have interests that differ from their counterparts in conventional construction contracts. With more moving parts, it's more difficult to button up contractual relationships and create patchwork of overlapping or gaps in responsibilities. Some of the development risks that's transferred includes design and development, construction, financing, and operational risks. P3 concessionaire, these are drawn from the Park Presidio project, has some degree of responsibility for environmental studies and permits, intergovernmental coordination, some rights-of-way responsibilities, some utility coordination, delegation, attempting to deal with stakeholders, some aspects of unforeseen conditions, and then the obligation to work with the life cycle operations for a 30-year term of the operation maintenance responsibility. Typical contracting organization, you have a building contractor plus a design firm. Sometimes the design firm is a subcontractor to the building firm. And then you have an operations and maintenance company, a facility services company, which is often a great opportunity to utilize underutilized businesses in the community. Talk briefly about a few case studies in California. A long-term successful project is the City of Burlingame Wastewater Treatment Facility. It was built in '72. It's the first U.S. P3 non-public management of a municipal-owned facility, and it's been very successful for 3 decades, the longest-running P3 in the United States. The SR 91 Express Lanes, another successful project. 4-lane toll facility, Riverside Freeway, $130 million project. Build, operate, transfer, 35-year franchise agreement between the California Private Transportation Company and the state of California. It was opened December 1995, purchased by Orange County Transportation Authority in January 2003 for $207 million. There was a contested non-compete clause, which takes us back to our original Charles and Warren case. South Bay Expressway project, SR 125, much less successful project. 12.5-mile highway alignment from SR 905 to SR 54 down in San Diego County, $653 million project. The southern 9.5 miles was privately financed and operated toll road using Fast Track. It's a limited partnership with San Diego Expressway. It held a franchise with the state of California. They financed and built it, and then were to transfer ownership to the state, with the LP leasing it back, operating and maintaining the facility for 35 years. That limited partnership is currently in bankruptcy as of 2011, and it resulted in an enormous amount of litigation amongst the design and build parties and the public. Another very successful project in Southern California is the Alameda Corridor Rail Project, which is principally a freight corridor in LA County. $2.5 billion worth of various projects that went together to create one of the most innovative transportation projects in California history. It's a 20-mile rail route, cargo route, connecting the ports of Los Angeles, Long Beach, and the rail yards in downtown Los Angeles. Believe it or not, 40% of all the imports that come into the United States come through either the port of Los Angeles or the port of Long Beach. So obviously it's a tremendously important transportation corridor. One of the largest design-build projects as well in the country. There was $1.2 billion in revenue-backed bonds, $400 million from the U.S. Department of Transportation alone, $394 million from grants from the ports of Long Beach and Los Angeles, $347 million from Los Angeles County MTA, and $160 million from other sources. Very, very successful project. The final one I'm going to talk about is another very good project. It is another water treatment facility owned by the San Diego County Water Authority. I was fortunate many years ago to help CH2M Hill with some of the beginning models and draft contracts and proposals for design, build, operate, transfer. This is one that eventually did happen. It was completed in 2008. Price of about $159 million. Again, design, build, operate, and transfer. And again, the private entity is CH2M Hill, which is unique in the sense that they have a tremendous design group as well as a project management group. In addition to that, they also have an operation and maintenance organization that has been involved in operating waste treatment plants around the country for decades. Very unique company. I'd like to talk now about the Presidio Parkway project. It's one that I've been counsel for the design build group for the last 4 years. It is a beautiful project. It goes through one of the most interesting parts of San Francisco, the Presidio base, which was created in 1776 as a Spanish fort. It connects, as you can see, the area around the Golden Gate Bridge toll facility, which is on the south side of the bridge, with the Palace of Fine Arts and the marina, and then into the financial district of San Francisco. It's important because it's in a historic district. It has a lot of history and archaeological issues, and it's a place of great scenic beauty. It's originally was called the Doyle Drive Reconstruction and Presidio Parkway Project. It's a replacement of the existing southern approach to the Golden Gate Bridge with a new 6-lane parkway. Began in 1998 with a feasibility study conducted by the San Francisco County Transportation Authority, pursuant to the memorandum of understanding with Caltrans. And then after that, Caltrans and FCTA entered into a series of cooperative agreements since 2003, 2006, and 2009 regarding the phase 1 of the project. It gave the San Francisco CTA a lead role in the project, also gave Caltrans a substantial degree of oversight. This shows the corridor, including both the tunnels and the viaducts. And this is, again, the first project in California to operate under the Caltrans P3 financial model. Concessionaire is a developer and is contracted to do the design, which is virtually complete now, building, financing, operating, and maintaining the project for 30 years. Caltrans is the lead agency with other stakeholders. Concession value is approximately $1.2 billion. Financing for phase 1 was about 33% federal money. The total budget for phase 1 was $468 million. Phase 2, which is the P3, has a total amount of $291 million for design build, of which 16% is federal funds. The federal agencies that are involved with the Presidio project are numerous because it's not only a coastal project, it's on a historic reservation. It includes the U.S. National Park Service, U.S. Department of Defense, Presidio Trust, the Federal Highway Administration, U.S. Department of Veteran Affairs, U.S. Army Corps of Engineers, U.S. Fish and Wildlife Service, and the National Trust for Historic Preservation, as well as many other neighborhood groups and other persons of interest. We had a case at the beginning of the project to try to halt it. The case was decided in August 2011. The challenge is whether or not the project was proper under Section 143 as a P3. And it was held that the project is appropriate. Caltrans has broad authority, broad project applicability, and tolls were not required to allow the P3 to go forward. We wrote a lengthy opinion letter to the California Transportation Commission before the project was approved, and that was used as part of the evidence and analysis during the course of the court's proceedings. PECG had hoped to limit the use of P3s. The challenge that the Presidio Parkway did not satisfy the P3 requirements was denied. Again, broad applicability of P3 in California was clarified. The P3 contractor may perform engineering work so long as Caltrans exercises supervisory control. It may be used for non-fee producing infrastructure. P3 may be used for substantial improvements to existing highways because there are supplemental to existing facilities. As I said earlier, existing corridors and existing facilities are particularly well suited to P3 because the environmental permitting to a large degree has already been accomplished. I'm going to conclude with Oakland Airport. It is not a classic P3, but it has many of those characteristics absent the financing part of it. It is a overhead people mover. The design builders are Flatiron and Parsons. The major equipment supplier, who's also by separate contract responsible for operation and maintenance of the facility, is DCC, Doppelmayr Cable Car, who produce approximately 80% of all the ski lifts and gondolas in the world, and are based in Wurfurt in Austria. The project is extremely successful and gives you about 15 minutes between the Coliseum station of BART and the airport, and vehicles are scheduled to depart every 4 minutes at peak. Total $484 million in the budget, and it's intended to be a seamless, smaller scale connection between the airport and the BART system. It's not necessary to bring the big BART cars all the way into the airport. The project belongs to BART at the end of 20 years. Thank you very much, and if you are in the audience now, you can ask some questions.